Subscribe to our channel, press the bell icon and never miss an update from Latestly.
The NDA government introduced the Personal Data Protection Bill in Parliament on December 11, 2019. This bill is a redrafted version of the bill that was originally authored by Justice Shrikrishna in 2018. The Personal Data Protection Bill envisages a framework to articulate and legislate who would control the collection, processing, storage, usage, protection, disclosure, and erasure of personal data of us Indians. But the current draft, which is with the Joint Parliamentary Committee, has raised concerns regarding privacy of Indians as well as their user rights. Speaking at an event organized by the Indo-American Chamber of Commerce and NASSCOM, voices from civil society, corporate India, and others articulated these concerns. Justice Shrikrishna was among the speakers. He explained that the current version of the bill empowers the central government to exempt any law enforcement agency from application of the proposed legislation, which gives sweeping powers to government agencies to collect data of citizens and risks making India into an Orwellian state. N.S. Napinai, an advocate who has extensive experience in cyber law, raises 3 points of concern with the current version of the bill. She points out that the bill creates a regulatory authority called Data Protection Authority of India. The bill talks about profiling on the basis of data, and she raises many questions regarding the data collection of minors. The advocate also raised a concern with the terminology profiling used in the bill, which according to her should have been replaced with marketing, as profiling has security connotations and should not be part of the language of the bill.
Firstly, why should we have a definition for profiling? It could have easily been marketing, because if you're saying you want to enable businesses, then allow for marketing. How can you give a legal validation for profiling? We have already seen all the negative aspects of profiling. Cambridge Analytica, according to me, was just the tip of the iceberg, right? So we do not want a situation where the word profiling is given a legal sanction, and let me just tell you what else comes from it. So there are provisions which allow for profiling of adults, and the only restraint there is that it has to be as per the discretion of the Data Protection Authority. That cannot be a ground for rampant profiling. What about others? Are we saying that if it is not someone who is collecting online data in this manner or in large volumes, they are allowed to profile children? Would we really want that happening? I feel that this is a large loophole which is there. There are many other issues and concerns, but these are the two, if you ask me for the two top issues, that I would put these two on top.
The bill also states that the centre can direct any data processor to provide any personal data, anonymized or other non-personal data to enable better targeting of delivery of services or formulation of evidence-based policies by the central government. But provisions like these are grey areas, and this concern was highlighted by Krishnanand Bhatt, CISA at SKP.
There are some draconian clauses which have been brought into play. There is an overarching power which has been given to the government, and there are some grey areas which have not been spelled out clearly. So we await to see that these clauses are amended. There was a transitioning provision which was provided for earlier, which has been done away with. So there is a clarity needed on that front. In the absence of any guidelines, rules, and the bill being taken to the Joint Parliamentary Committee, we feel they'll look into this and try to bring out a more balanced act, which at one end provides rights to individuals about their privacy, and at the same time is able to be a torchbearer to fulfill global requirements.